Good afternoon, ladies and gentlemen. We start a bit late, 10 minutes, so I'll be very short, introducing myself as only Sławomir Redo from the United Nations Studies Association and visiting professor of UN law. There should be a correction. I no longer am affiliated with the University of Vienna. We have today a very special panel, not only because outside we have a very snowy time in Vienna, which is a rarity, but also in this very afternoon we have a very hybrid panel. The hybridity of the panel you see on the screen on the left, and you see the two presenters in person, Valentina Carraro and myself here. So without further ado, I want to open the panel under the title Strengthening the Social Contract, Development, Human Rights and Democracy. And I would like to ask to take the floor to our first panelist, Mr. Pablo de Greiff. He's a member of Independent International Commission of Inquiry on Ukraine and formerly Special Rapporteur on the promotion of truth, justice and reparation. The second panelist will also be online with a pre-recorded interview. This will be Mr. Konstanty Gebert, a journalist from Warsaw, a historian of memory, who will present in this interview a topic, double standards, question mark, Israel and the United Nations. So not the topic that you see here on the written invitation. Then next will be Professor Adams Bodomo, Professor of African Studies, University of Vienna, and he will speak about linguistic human rights for the promotion of democracy in West Africa. I will come to this very intriguing topic and speciality later, but finally I would like to confirm that we have on the left side, of my left side, Professor Valentina Carraro, Assistant Professor in Global Transformation and Governance Challenges from Leiden University, from the Netherlands, speaking about the strengthening of the Human Rights Council and the UN treaty body system. So without further ado, Mr. de Greiff, you have the floor, please.
Thank you very much. First of all, can you hear me correctly?
Yes.
Okay,
yes.
Thank you very much. I, of course, want to start by thanking the organizers for the very kind invitation and reiterating my regret for not being able to join you there, which is what I would have preferred, not the least, to learn from the other sessions and to have the pleasure to join my other panelists. But thank you very much for the invitation. My talk, and perhaps I should start by acknowledging this, doesn't really present a broad structural reform of the United Nations system. I have to confess that this is not my specialty. I want, however, to present a proposal about a thematic orientation that does involve and would involve, if adopted, a different way of working, a much more integrated cross-pillar work, and that I think would have many different benefits, but would also require new competencies within the system. And that is, I want to talk about something that the system talks about frequently and has been doing it for decades, which is to adopt an effective prevention strategy. So obviously, this is not a new topic to the system. Some of the predecessors of the current Secretary General have spoken about it. Boutros Ghali in 1992 presented his agenda for peace, already emphasizing prevention. Kofi Annan, in his report From Reaction to Prevention, as the title suggests, did the same. The big reports that were commissioned in 2014, the HIPPO report, the AG report, the report on the 15th anniversary of the 1325 resolution, all converge on the conclusion that the UN system needs a broadened and upstreamed prevention agenda. The same conclusion is reached by the World Bank United Nations report Pathways for Peace in 2017. It's hard to believe that that's already 5 years ago. And the current Secretary General, both in his Common Agenda report and in the call to action, makes reference to prevention, a topic that he broached, for example, from his very first meeting with the Security Council, where he said that this was not merely a part of his agenda, but the core of his agenda. And he reiterated the obvious point that the system spends a lot of resources trying to cope with the consequences of crisis, and that a new strategy was necessary in order to prevent the crisis. In both in interventions at the Human Rights Council and in his call to action, he also adds a point which is important from my standpoint, which is that the best preventive tool that countries have at their disposal is the Universal Declaration of Human Rights. Despite that consensus, however, and despite the insistence on the importance on the topic, the issue continues to pose serious challenges within the system, and to be fair, not just to the system, but to others as well. So it is not that, for example, international cooperation agencies do significantly better regarding a comprehensive understanding of prevention. The challenges are manifold, but conceptually, the notion of prevention continues to be used in a very inconsistent way, both within the system and outside. It is a very porous concept. So I want to make clear that here, by contrast, I want to define the object of prevention. I will not be talking about prevention of all sorts of undesirable phenomena, including conflict, violence, interpersonal violence, etc. I will concentrate my attention primarily on the prevention of mass human rights violations, which nevertheless makes sense as a sort of building block for a comprehensive prevention strategy, because mass human rights violations, of course, involve a great deal of violence, are often the precursors of conflict, and therefore addressing them will help to prevent, at least indirectly, some conflicts and also some forms of violence. Substantively, the organization continues to lack a comprehensive policy. it has to be acknowledged that there has been some progress analytically in terms of what the organization requires, for example, through the common country assessments, and also that there has been some progress in terms of the creation of forums where prevention discussions can take place. And I'm thinking both of the RMRs and some of the discussions at the ECDC. Operationally, however, fragmentation is still the name of the game. The proliferation of frameworks, of course, doesn't help in order to create a more coherent and integrated response. The work continues to be reactive, very often disjointed and incoherent, and for the most part, it can be characterized as a sort of a scattershot approach to issues of prevention. And again, just to be fair, I want to make sure that the message comes clear that this is not just a problem for the United Nations, but for others as well. One of the greatest problems in the treatment of prevention from my standpoint has to do with the focus that most of the discussions about prevention within the system has, and that is they focus on crisis prevention. I hasten to add that it's not that I am critical of crisis prevention in general. I think, of course, crisis prevention is important in many situations, but to reduce discussions of prevention to crisis prevention has some pernicious consequences. And some of them include the following. I think that the focus on focus prevention provides an incentive for paying special attention to the role of the international community. And that in turn has two undesirable consequences. First, that you do not capture the initiatives that do the bulk of prevention work ongoingly on an everyday basis at the national level that have very little to do with, for example, diplomatic good offices. But secondly, it awakens fears amongst many member states that the prevention agenda is a backdoor for intervention in their internal affairs. So I think that there is a lot of de-dramatization that needs to take place in order to deal with this topic adequately. The proposal that I have been working on now for many years consists in the adoption of what I call a framework approach to prevention, one that would take human rights not just as an ex-post redress mechanism, but that would pay attention to the function of human rights as anti-grievance mechanisms, that is, pay attention to their ex-ante function of prevention. And it would also take seriously the old sociological argument that sustainable social change is not simply a matter of clever institutional engineering, but that it also requires changes, of course, at the level of institutions, but also changes at the level of economic opportunities, at the level of societal relations, at the level of personal dispositions and convictions, and also in the cultural sphere. I think that the adoption of a framework that involves elements at those levels would solve some of the problems that I mentioned before. It would give content to an upstreamed and broad prevention agenda. By focusing on national initiatives, it would de-dramatize the topic and assuage the fears about international interventions. It would help break down silos of knowledge and expertise, which I think is one of the greatest obstacles for the development of a sound prevention policy. The problem here is not dearth of knowledge, but the fact that we have focused on the wrong topics, and it would enable more integrative response. In terms of content,
De Greiff, we have still 2 minutes. Could we ask also for some conclusions?
Yes, I was getting there precisely.
Okay, thank you.
In terms of content, the framework would include elements of different degrees of ambition, from the micro to the meso to the macro level, different degrees of resource intensiveness, and different requirements concerning institutional coordination. It would include very familiar elements having to do with legal and judicial reform. It would pay attention to security issues, including policing and the way in which counterterrorism operations take place. In terms of the domain of economics, it would pay attention to, for example, phenomena like state capture that are particularly worrisome these days. It would take seriously the rhetoric that is given about the preventive role of civil society, thinking about civil society not just in terms of pigeonholed particular functions, but of the notion that a strong, robust, and inclusive civil society is itself a preventive element, and therefore the system would need any work of working with civil society, and it would be much more attuned to cultural and personal disposition issues, including issues having to do with strengthening solidarity and tolerance. I think that that shift in focus on prevention, which again would require the system to acquire new competencies and to be much more effective in terms of cross-pillar work, planning, and strategy making, would do a lot to recover the relevance of the system and to make it much more clear what its role at the national and at the international level can also be. So I'll stop here, and I will be happy to discuss later.
Thank you very much, Mr. de Greiff, for this very general and comprehensive statement. I'm sure there will be questions from the audience to you, but we will collect these questions later and get them also via the Facebook. So in the meantime, I would ask now to show the interview with Mr. Konstanty Gebert. It's a part of the entire interview, the whole interview, because of this 12 minutes limit, will be in full put on YouTube.
Thank you very much for inviting me to this very important and very necessary conference. I very much regret that I cannot be in Vienna in person and that I have to deliver my presentation through a pre-recorded video instead. The title of my presentation is Israel in the UN, a Case of Double Standards. On the penultimate day of last year, the UN General Assembly, by 87 votes in favor, 26 against, and 53 abstentions, voted to request of the International Court of Justice an advisory opinion on Israel's, quote, prolonged occupation, settlement, and annexation of Palestinian territory, unquote. Resolution A/77/400 was very strongly criticized by Israel as politically one-sided, and indeed the high number of states which refused to support the motion seems to indicate a certain unease. But this is puzzling. The aim of the resolution is to find out if an occupation, which, as the resolution itself states, should be temporary, can in fact be considered temporary 55 years after it started. If no, then it would be legitimate to say that we have to do with a de facto annexation, even if the relevant legal acts have not, with the exception of 400, is therefore noteworthy in its attempt to obtain legal opinion on whether there is a time limit on occupation, an issue of some international importance, as it affects several ongoing crisis situations in Asia, Africa, and Europe. It also allows a closer look at the situation of Israel within the United Nations, which also is something of importance, as the country is considered to be the world leader in disregarding UN resolutions directed at it. A closer reading of the text of the resolution explains possible sources of the assumed unease of member states which voted against or abstained from the vote. Of the 8,720 words of its English version, many are just technical legalese, but the brunt of the text is a damning indictment of Israeli actions in, quote, occupied Arab territories, unquote, which reads like a catalog of horrors. This in itself should not be surprising. Occupation cannot fail to be brutal. Yet what does surprise is the fact that in that long text, only 2 fragments, 38 words in total, condemn violence against Israel as opposed to violence by Israel. These are: the General Assembly, quote, also condemns all acts of violence by militants and armed groups, including the firing of rockets against Israeli civilian areas, resulting in loss of life and injury, end quote, and, quote, condemning acts of violence and terror against civilians on both sides, end quote, the General Assembly, etc. 55 years does not, in fact, seem to meet the definition of temporary, but 38 out of 8,720 does seem to meet the definition of one-sided. Furthermore, these are the only fragments in which the very existence of sides is referred to, implying thus the existence of a conflict, even if the non-Israeli side is vaguely described as unidentified, quote, militants and armed groups, unquote, apparently deprived of any political, national, or institutional identity. Otherwise, the text speaks of Israeli violence alone, as if it were an unprovoked and arbitrary manifestation of maliciousness. The authors of the resolution have doubts about whether the word occupation is valid, given the time lapse. Yet they do not seem to attach any importance to the fact that the use of this term itself might be inappropriate for reasons of substance and not only of circumstance. It can be argued, and this has been the position of the Israeli government, that the relevant Fourth Geneva Convention of 1949 applies only to the, quote, occupation of the territory of a high contracting party, and nobody, end quote, and nobody was sovereign on the territory of Mandatory Palestine after the end of the mandate in May 48. Israeli sovereignty over the territory it controlled within the ceasefire lines of 49 was eventually recognized by the international community through the act of recognizing the country itself, and the country adhered to the convention in 51. Neither the Transjordanian annexation of the West Bank and Eastern Jerusalem nor Egyptian administration of Gaza were so recognized, and therefore no sovereignty was exercised over these territories when Israel conquered them in 67 in a war of self-defense. No sovereignty, no occupation. It can be argued that the UN's gradual and still incomplete recognition of the PLO and then of the State of Palestine has rendered this issue moot. Yet it is surprising that such an elaborate legal document as A/77/400 makes no reference to the debate about the crucial term used. Most legal opinion, however, rejects the Israeli position by arguing that the country is obliged, as a high contracting party, to respect the convention as its text says, quote, in all circumstances, end quote. That is, regardless of whether the territory in question is in fact occupied and not just contested. The fact, however, that not even 38 words are dedicated to this issue seems to imply that the authors do not consider it of any relevance. Yet it is relevant, at least for understanding the motivation, be it mistaken, of the country which is the object of the resolution. Regardless of whether the West Bank is to be considered occupied or contested, the question remains whether a situation of military control, which has applied for 55 years, can be considered temporary. Because if no, then even if the territory was indeed just contested and not occupied, we are faced with a de facto annexation becomes truly irrelevant. Yet in law, it is notoriously difficult to reach a general opinion on the basis of one case alone. The court will have a hard nut to crack. Sadly for those afflicted, however, but usefully for the deliberations of the court, the issue of the West Bank is not unique in the post-World War II world. Other occupations of comparable length or longer also exist. And here I describe in detail in the written text the occupation of Kashmir by India and Pakistan, the occupation of Northern Cyprus by Turkey, the occupation of Western Sahara by Morocco, and the occupation of Karabakh by Armenia. Referring the audience to the written text, I continue. Surely the General Assembly, if it wants the ICJ to opine on when does an occupation become an annexation, should have requested an examination also of these cases of occupation, alongside that of the West Bank. 5 examples instead of 1 would provide grounds for a deeper legal analysis. Yet A/77/400 makes no mention of those other occupations, not even the fleeting glance it affords to violence directed at Israel. It would seem that the motion regarding Israel's occupation is interested in Israel, not the occupation. This, however, is a bizarre conclusion. Why should the UN be specifically interested in one member state only? There seems no reason for it, but the allegation itself can be verified. It is enough to look at the number of resolutions adopted regarding that country and compare it with those regarding other member states. Although the UN has taken positions on Palestine ever since its creation, we should start with S/RES/233, passed on June 6, 1967, as only with that date, the outbreak of the 6 Days War in which the West Bank was occupied, can we speak of resolutions regarding the occupation. Since then, no less than 373 Security Council resolutions were passed, all of them in one way or another critical or condemnatory of Israel and its policy. This is more than the combined number of all the resolutions passed on the other 4 cases of occupation, including that of Kashmir, which has been going on for longer. and constitutes a staggering 20% of all Security Council resolutions passed since the Six-Day War. And if not for the US veto, used at least 53 times till 2021 to block anti-Israel resolutions at the Security Council, that number would have been higher still. This is already stunning, but the ratio would have been even higher if we considered not only the Security Council, but all UN bodies which have passed resolutions critical of Israel or condemning it. The Commission on Human Rights had passed from June 67 till its disbanding in March 2006, 95 resolutions condemning Israel, a full half of all of its country-specific resolutions. It also makes Israel the object of the sole permanent point of the agenda of its sessions. Finally, even the then Secretary General Kofi Annan was forced to admit that, quote, the Commission's ability to perform its tasks has been undermined by the politicization and the selectivity of its work, end quote. The Council on Human Rights, which replaced the Commission, however, proceeded to continue the traditions of its predecessor. The permanent point on the agenda remained, and so did the targeting of Israel, which continues to be the object of about half of the Council's country-specific condemnatory resolutions. In 2022, the year Russia invaded Ukraine, committing crimes of war and crimes against humanity, when China was found to be guilty of severe repression of Uyghurs, which, according to several UN member states, could be considered genocide, when in Ethiopia, the war in Tigray killed an estimated 600,000 people, when Iran proceeded with the massive repression of protest demonstrations triggered by the killing of a young woman at the hands of the police, and Myanmar continued its savage repression against opposition to the military coup, to mention only the most egregious human rights violations, the General Assembly passed 15 resolutions critical of Israel versus 13 critical of all the countries in the world combined. Russia, Iran, and Myanmar rated 1 each. China and Ethiopia, not even that. This is consistent with previous General Assembly practice. Since 2015, it had passed 140 resolutions criticizing Israel versus 68 targeting the rest of the world, a staggering 2-to-1 ratio. But even so, one may legitimately ask, is it not a good thing that Israel is being investigated? After all, there are good reasons for it. Evidence of human rights violations, including possible war crimes and crimes against humanity, is sadly abundant. And Israeli justice, though deservedly considered observant of rule of law, clearly does not address many cases or punish perpetrators with sufficient severity. Furthermore, if the current Israeli government implements the clause of its coalition agreement stipulating that, quote, the people of Israel has an exclusive and unalienable right to the land of Israel, end quote, we will be faced with abuse of basic rights as government policy. It is obviously true that investigation is always desirable if it is unbiased and fair. In the worst case, it will simply be redundant, as relevant national institutions will have done their job anyway. And even if the reasons to investigate Israel were biased and unfair, this does not necessarily prejudice any particular investigation per se. The conclusion should be that all countries need to be subjected to the same standards of scrutiny as Israel, not that Israel should not be scrutinized. Implementing that conclusion, however, would, as budget and manpower are limited, necessitate either moving some of the low-fare firepower currently directed at Jerusalem to other targets instead, or drastically increasing the UN budget. As either decision would have to be made by member states, to the detriment of their political standing or their financial coffers, it is fair to assess that both are pipe dreams. It goes beyond saying, of course, that a prerequisite for the investigators to be unbiased and fair themselves. This, sadly, has often not been the case in respect to UN investigators of Israel. Take only the most recent example, Francesca Albanese, who heads the Human Rights Council's open-ended investigation of, quote, Israeli practices, end quote, regarding Palestinians. In December last year, the Times of Israel portal revealed that during the 2014 Gaza war, she had published an open letter in which, inter alia, she said, quote, America and Europe, one of them subjugated by the Jewish lobby and the other by the sense of guilt about the Holocaust, remain on the sidelines and continue to condemn the oppressed, the Palestinians, who defend themselves with the only means they have, deranged missiles, instead of making Israel face its international low responsibilities, end quote. In another post from that year, she had criticized the BBC's coverage of the war, saying, quote, the Israeli lobby is clearly inside your veins and system, and you will be remembered to have been on the Big Brother side of this Orwellian nightmare created or caused once again by Israel's greed. Shame on you, BBC, end quote. Allegations of a Jewish lobby subjugating the US are clearly anti-Semitic. And the image of that lobby inside anybody's veins as a toxin or a pathogen just reinforces that interpretation. So does the allegation that the Gaza war was caused by Israel's greed. There sadly is nothing to be greedy for in Gaza, but greed as a prime Jewish motivation is anti-Semitic standards fair. Furthermore, the belief that the Palestinians are just defending themselves with rockets, while it was the firing of those rockets that was the cause of the war, is both a confusion of cause and effect and the legitimization of what even the Palestinian ambassador to the UN had called a, quote, crime against humanity, end quote. Contacted by Times of Israel, Albanese had initially said, quote, some of the words I used during Israel's offensive on the Gaza Strip in 2014 were infelicitous, analytically inaccurate, and unintentionally offensive. People make mistakes. I distance myself from those words, which I would not use today, nor have I used as a UN special rapporteur, end quote. Hardly a ringing condemnation of unacceptable rhetoric, but clearly a step in that direction. Yet barely a day later, seeing that no UN criticism of her words of 2014 is forthcoming, apart from the reaction of the US and Israeli missions to the UN, the Americans had said they are appalled, she changed her position. She said that her comments were, quote, wrongly mischaracterized as anti-Semitic, end quote, and that the Times of Israel report was, quote, decontextualized and disingenuous extrapolation. Should anyone feel the urge, she continued, to be appalled about something, please consider the 215 Palestinians killed this year. 6 Israeli soldiers and settlers were also killed, end quote, she added. It is not clear what she was referring to. According to UN data, there had been 191 Palestinian fatalities and 21 Israeli ones, both combatants and civilians, in all of 2022. Ms. Albanese is, of course, entitled to her opinions, bizarre as they may be. However, it does not seem reasonable to entrust the investigation of, quote, Israeli practices, unquote, to someone who believes a noxious Jewish lobby is running in the veins of the BBC, that Israel attacked Gaza out of greed, and that Palestinians have been firing rockets from it in self-defense, and who cannot get her figures straight. Anyone with an aspiration to impartiality would, in such a situation, have resigned. without protesting that her anti-Semitic opinions are not anti-Semitic, as Ms. Albanese did. Since she failed to do so, she should have been removed from her position by the UN itself, out of concern for the impartiality of the probe and the concomitant danger to the institution's reputation of fairness. Since this did not happen, one can only conclude that the UN sees no problem in Ms. Albanese holding such views while investigating Israel, just as it apparently sees no problem in considering that half of the world's evil is located between Akko and Eilat. It is staggering that nobody much seems to see a problem with the UN not seeing one here. Thank you for your attention.
Now we continue with another hybrid presentation. Professor Adams Bodomo will speak about linguistic human rights for the promotion of democracy in West Africa.
I'm normally a professor at the University of Vienna, but this year I'm spending my sabbatical leave at the University of Ghana in Accra. So I'm speaking to you from Accra. And I wanted to thank all the organizers, especially Professor Redo and my friend Conprox for inviting me to be a part of this wonderful conference. Now, I don't know how to be going up and down. Oh gosh, yeah. Okay, right. So my talk in the UN Secretary's, my talk is titled Linguistic Human Rights for the Promotion of Democracy in West Africa. Now, in the Secretary General's declaration on the 75th anniversary of the UN titled Our Common Agenda, the following points were raised. You know, we will not leave, we will leave no one behind, we protect our planet, we will promote everything all the way until we will be prepared, and so on and so forth. So even though democracy is not mentioned in these 12 points, democracy as an ingredient is needed, you know, for all of these to be achieved. Indeed, the first point, we will leave no one behind, is a basic tenet of democracy, which is inclusion. I want to argue in my paper that to develop inclusive democracy in a multilingual setup like West Africa, and that's, I'm just talking about West Africa, but it could also apply to the whole of Africa and indeed to many parts of the global South. So in a multilingual setup, linguistic rights such that we need linguistic rights such that all citizens can be able to participate in the democratic process. Indeed, the United Nations has designated the period from last year, 2022 to 2023, as the year of indigenous languages. And as contained in a website dedicated to this, you know, these are some of the objectives. The International Decade aims at ensuring indigenous people's rights to preserve, revitalize, and promote their languages and mainstreaming linguistic diversity and multilingualism aspects into the sustainable development efforts. You know, and it goes on and on and on. And so it is a clear promotion of, a clear attempt to focus on the promotion of and revitalization of indigenous languages. And this is a motivation and an opportune time for scholars of language studies like me to talk about promoting indigenous languages. And one way to do this for me is to look at linguistic rights or the right of and to language by communities within the perspective of human rights. My paper seeks to put human rights, language rights or linguistic rights in the wider issue of human rights, which is an important part of this panel. Human rights as a concept encompass the setting up of norms or standards of behavior that go a long way to protect the lives and dignity of humans. For instance, all human beings deserve to live and have a right to hold property and to have a right to fair trial in case they face judicial processes. They have freedom of speech, but do they have right of and right to language? And this is the crux of my paper. And we need to understand what language or linguistic rights are and how scholars can help, of language can help to enrich the general notion of human rights to make our world a better place to live in. Some research questions that must be addressed are what are linguistic rights and how can scholars of language studies help enrich the notion of human rights for a better and more democratic world? And democracy is one of the important ingredients of this panel. The paper, therefore, examines the interrelationship between linguistic rights and human rights as universal concepts before applying them to the African context. We outline approaches taken by some African actors to use technology. Just now, yesterday, when I was listening to some of the panels, or was it this morning, somebody was saying that at what point should we, the people, take things into our own hands and do things rather than wait on our governments and on the UN itself. So in my paper, you are seeing that people are taking the things in their own hands and going ahead to find ways to promote their own languages. I will mention a few of them as some part of the relevant part of my paper. In terms of my literature review, of course, I did a substantial work. There's a lot of work on human rights generally and linguistic rights more specifically. And UNESCO has a history of promoting linguistic rights, especially with the 1999 Declaration of, and then also now with this last year's declaration. So UNESCO has this habit of promoting these rights. So there is a lot of work in this area. However, in this presentation, we consider those works that intersect human rights and linguistic rights, especially with reference to the African continent. Now, the late Kenyan scholar, Ali Mazrui, is among the earliest to focus on the link between human rights and linguistic rights. In a series of publications, he made important contributions, among others, to identifying two kinds of rights with regard to language: the right of language, which is the collective right, and the right to language, which is individual rights. This is, I will explain this later on. But there are other studies in terms of literature review that have linked these two concepts, human rights and linguistic rights, including works by Ndlovu, Edwards, and Helstein. Most of these studies emphasize on the fact that linguistic rights are an important part of human rights. This presentation builds on these studies on how showing how some language activists and scholars are working towards improving, the view of linguistic rights as human rights in Africa. In terms of theoretical analysis, I argue that the best way to address the concept of linguistic human rights in Africa by linguists and other scholars is to emphasize the theoretical notion of Pan-Africanism and manage our linguistic Pan-Africanism and manage our resources in such a way that we can mitigate injustices and inequality on the basis of language. And these are some of the tenets of linguistic Pan-Africanism that I have been trying to develop myself. The theory of linguistic Pan-Africanism has several underpinnings. The first being the primacy of indigenous African languages. The most important thing in this concept is that all indigenous African languages are important for the socio-economic development of Africa. And again, development is an important concept in this panel. Then mother tongue education. A tenet is that each of these indigenous languages is a mother tongue or language of cultural identity of individuals, in various communities in Africa. So indigenous mother tongue education, they need to ensure that all African children can speak, read, and write in at least one of their mother tongues or language identity is an essential feature of the theoretical model of linguistic Pan-Africanism that I outlined here. Of course, we also believe in the fact that linguistic Pan-Africanism has the idea, or emphasizes linguistic human rights and recognizes that linguistic rights are an essential part of the broader notion of human rights. And several scholars have mentioned this. The important maxim of right of language and right to language, as mentioned by Mazrui, is crucial in this model. As Ndlovu explained, the right of language is a collective right whose violation automatically affects entire speaking communities. This means that language policies that deliberately seek to suppress some languages would be a violation of the right of language. The right to language is more of an individual's right to use one or more languages of choice. And again, Masrui explains that the right of language, the right to language as the right to use the language one is most proficient in, as well as the right of access to the languages of empowerment and socioeconomic advancement. So all these are important concepts. And if I had time, I will explain that. Now, another tenet is linguistic diversity as a global future. Within the UN concept, we talk a lot about global future, but language is an important aspect of our global future. There's therefore a clear link between language preservation and environmental protection. For example, would be the point of preserving all kinds of plant and animal species in our communities when we lose the indigenous languages for naming and relating to these plants and animals. And if climatic and environmental sustenance are important global features, language is also language and its preservation are also an important part of global future. The theory of linguistic Pan-Africanism also proposes the development of regional lingua franca and possibly a continental lingua franca of communication among Africans. And I have a diagram that just shows this, where at the base of the diagram, you have mother tongue education. In the middle, you have the development of regional lingua franca. And at the top, you have the possibility of developing a language like Swahili, which we Pan-Africanists call Afrihili, as a continental medium of communication, rather than the former colonial languages like English and French. Linguistic Pan-Africanism, if well implemented, guarantees an inclusive democratic approach to the languages of Africa. Seeing linguistic rights as human rights is a good way to inclusive language planning, which can be the linguist's contribution to sustaining peace, democracy, and security in West Africa, and also minimizing the incidence of insecurity that may be due to people feeling excluded because of their language, because their languages are not used. I will now jump and look a little bit about some of the approaches that individuals have just taken, rather than waiting on government or bodies like the UN, they've just taken to promote their languages. In this section of the presentation, I first point to a survey of various measures taken by language activists across Africa to promote the use of indigenous languages. I also have a case study, but I won't have time to mention that. Digital activism is what I'm talking about. The processes and the idea of going online and trying to promote your language is what we call digital activism with respect to language. So digital activism or internet activism is generally the use of the internet as a platform, as a means of communication to promote some cause or the other. In this presentation, the notion of digital activism as a strategy to promote the tenets of linguistic Pan-Africanism, which include the development of indigenous languages, the promotion of the mother tongue education, and the promotion of linguistic human rights as subject matter. So in a significant report by Evelyn Leary, we see the kind of work that various activists are doing across Africa. So as she states, across Africa, language digital activists are now playing a proactive role in advocating for a multilingual web that aims to ensure that the information available on the net is as diverse as the languages that exist on the continent. Using a do-it-yourself approach, language activists are making use of a variety of digital tools to tweet, to localize software, to create audiovisual materials, and to contribute to Wikimedia projects in their mother tongues. And then several projects are described, including promoting languages like isiZulu, Dagbani, Igbo, Ga, and so on and so forth. So in Ghana, for example, where I come from, Sidik Shahadu, a co-founder of the Dabani Wikimedia User Project, is spearheading a project to increase the visibility of the Dabani language, which is the language of Northern Ghana, which is spoken by 1 million people in Northern Ghana. And to date, 400,000 words have been uploaded to Wikimedia. The team works with language experts, correcting spelling and doing other things to improve the content. In Nigeria,
we are short of time, Professor Bodomo.
Ozurumba is working on the Igbo Wikimedia user project. And
if you could please conclude.
Despite the fact that Igbo is one of the widely spoken languages of Nigeria and indeed Africa as a whole, there's a dismal information on women and other Wikimedia aspects in the platform. So this activist is doing her best to, to remedy the situation.
Professor Bodomo, thank you very much.
In South Africa, Sia Masuku, a writer and illustrator in indigenous languages, is promoting isiZulu through illustrated alphabet books and comics that target school children. And so all these are aspects that go on. I won't go through all of them. Back to Ghana, there are many other people who are doing this on languages like Ga, Chui, and so on and so forth. So what we see is that at least 5 African languages, Dabani, Ga, Igbo, and Zulu, Akan as well, are being promoted by the use of web technologies to make materials available online in order to guarantee the rights of speakers and of language to use the languages online.
Professor Bodomo, thank you
very much.
But
I don't have time for it, so I'll just go ahead and conclude.
This is really the time we have to really continue with other presentations.
Yeah, let me just conclude. Can I just conclude?
Just 2 sentences, please.
Okay. Linguistic human rights or those aspects of a general notion of human rights relating to language specifically are an important aspect of the rule of law and of the functioning of democratic society. My paper has sought to explicate the notion of linguistic rights by providing answers to specific questions such as what are linguistic rights and also how can we use the notion to promote a better, more democratic world. We use the theoretical framework of linguistic Pan-Africanism for our discussion because it is, as it can be seen in the section, linguistic Pan-Africanism has certain tenets that promote indigenous languages and linguistic rights, stressing that every child has a right to mother tongue education and that community and individuals have the right to maintain, develop, and revitalize their languages.
Thank you very much. With this presentation, we will also have a number of questions, but before we can
as a further discussion, it remains to be seen how the legal profession and educational framework for the promotion of linguistic human rights. Thank you very much.
Before we ask any questions, I would like to ask Professor Valentina Carraro to speak about strengthening the Human Rights Council and the UN treaty body system. She is the real person in a real situation concerning the Human Rights Council. So please start your presentation.
Thank you very much, and thank you for having me here. So much has been said about how to reinforce individual procedures or mechanisms of the UN human rights system. One of the most recent examples is the 2020 review on the strengthening of the treaty body process, which has led to a number of very important recommendations and agreements on how to move forward. But what we have to a much more limited extent is an understanding of how the different parts of the system can work together to strengthen each other and to maybe offset each other's weaknesses if there are. So what I'm going to do in this presentation is to discuss with you some results from a research. I've worked on these mechanisms for the past 10 years and highlight some possible ways forward for the different parts of the UN human rights machinery to work together in a different way. For those of you who maybe are less familiar with these mechanisms, I focus specifically on 2 sets of procedures. One is the UN treaty body system, so these bodies of experts that are created to monitor the implementation of the major UN human rights treaties. And on the other hand, the Universal Periodic Review, which is one of the key mechanisms of the Human Rights Council, which is a political mechanism. So it's very different from the treaty bodies, which are expert bodies. The UPR, Universal Periodic Review, is a peer review where states give recommendations to each other on how to improve their human rights situation. While it is different from the treaty bodies because of its political nature, it's also comparable to one of the procedures of the treaty bodies, which is examination of state reports. Because in both UPR and treaty bodies, states submit a report in the UPR is every 4 years, in the treaty bodies it depends, but submit a report on their human rights situation, and then receive a number of recommendations for improvement. So procedurally, these two systems are similar in this regard. The way in which I conducted my research on these bodies is to combine a different number of data collection strategies. So first of all, analysis of documents, all the recommendations by the treaty bodies and those in the UPR, but also interviews with directly involved participants, especially focused on diplomats, UN officials, treaty body expert members, and NGO representatives, a survey with a similar target group, and then by attending some sessions of UPR and treaty bodies to get a better understanding of their functioning. In the next few minutes, I will discuss with you what emerged from my research as key opportunities and challenges faced by these mechanisms, but then I will focus more in depth on their complementarities and on a project I conducted to actually measure the extent to which they're complementary. When it comes to opportunities and challenges, let's say, the UPR as a political mechanism is very strong in generating pressure for compliance, both in terms of peer pressure, so because we have states giving recommendations to each other, these recommendations normally have quite a strong political power and a strong compliance pull for states, and also public pressure because it's quite a visible, transparent, easy to access mechanism. So it's also picked up extensively by, for example, local NGOs and civil society. The treaty bodies, on the other hand, and in this you can already see the complementary nature, are very technical, objective, high-level mechanisms where there are experts in their field that give recommendations to state. And this leads to very accurate assessments of states' human rights circumstances, as well as helpful guidelines for states to improve. On the other hand, the strengths of these two mechanisms lead to some challenges. The UPR is a highly politicized mechanism, also very often accused of double standards, as we also heard in a previous presentation, where indeed, in some cases, some would argue in many cases, it's political considerations that drive the recommendations and the acceptance of the recommendations more than human rights considerations. So this is one concern. And another challenge is that recommendations, because they're very political, they tend to be also very broad, not very detailed in helping states, and therefore it's also more difficult to conduct a systematic follow-up of such broad recommendations. When it comes to the treaty bodies, again, their expert nature also leads to some challenges. First of all, because there is little pressure for compliance, because it's a more technical mechanism. States, at least that's what I heard in my interviews, in my research, they feel less pushed to comply with the recommendations. So they do if they want to do it. They find them helpful if they want to improve. But if not, they tend to let them go in some cases. And the other challenge that they face is that there are very high expectations from the state representatives that join the reviews. Expectations of high quality of the recommendations they receive. And when these expectations are not met, maybe some members sometimes act in a more political manner or are perceived to act in a more political manner, or recommendations maybe are not really to the point of what the representative would want to receive help with, then this leads to very strong frustration. So if we look at this as an overall picture, we see that the strengths and challenges faced by these mechanisms are quite complementary. So one is very political with the pros and cons that come from it, and one is very technical and expert-based, again with pros and cons. And the system is also very fragmented. We have 10 treaty bodies and 1 UPR. So the question here is, how can we make sure that these mechanisms work in a complementary way so as to correct for each other's weaknesses and maybe booster each other's strength. To do that, or to start looking into this very, very broad topic, I conducted a study on 14 countries from all UN regions to look for the complementarity in the recommendations that these different bodies deliver. So I looked at these 14 countries in the period of 2012 until 2016, and all the recommendations they received on issues of torture and ill-treatment by the UPR and by all the treaty bodies that are relevant. So not only the Committee Against Torture, but any other treaty body that raises issues of relevance for that, such as the Human Rights Committee, for example, or a Committee on Racial Discrimination. And I looked to the extent to which recommendations delivered to the same countries in the same period were repeating each other, were contradicting each other, or were talking about different sub-parts of the broader torture issue. What I discovered is that 60% of the recommendations that the states received did not overlap. So they touched upon different issues related to the fight against torture, which is a positive indication, or it emerged to me as a positive fact, because this mechanism then seemed to really cover each other's gaps and together give a very, very full and thorough overview of how a state is faring when it comes to torture. However, we also had almost 40% of recommendations that were repetitions to different extents, but many of these, about 20% of the 40%, were literal repetitions. So you could look at the recommendations and they were with exactly the same words delivered by different bodies to the same state. And based on the discussions I've had with diplomats, treaty body experts, and other actors involved, it seems that these repetitions help in a way because they highlight which issues are urgent. So states really feel pressure because they receive the same recommendation from different points. And also because the UPR is such a political mechanism, when UPR recommendations are directly coming from the treaty bodies, so when states in the UPR pick up recommendations from the treaty bodies and deliver them to states, it really helps to give them political power. As we saw before, treaty bodies tend to have less political pull, so that the UPR can help in that. But there is also a downside to these repetitions. First of all, it leads to frustration when it is excessive. So a bit of repetition is useful, but when almost everything is repeated, when there is a lot of repetition, especially among different treaty bodies, this is seen as frustrating. This is seen as also states wasting time sometimes and resources to attend different reviews in which they hear, in many aspects, the same things. And the second problem is that states in the UPR can support or not recommendations. Now, what I say for some might be controversial, but noting is often a euphemism for not accepting the recommendation. So when they support them, they commit to implementing them. When they note them, they might or not. But often there is a note added to the response to the recommendation in which they say, we will not further consider this recommendation. So in these cases, at least we can say they are rejected. And this is problematic because in the UPR, they can be rejected. In the treaty bodies, not, because of course there are authoritative interpretations of treaties. So when a recommendation in the UPR repeats a recommendation in the treaty bodies and it is rejected, and this happens a lot in the cases that I looked at, that is a problem because it undermines the compliance with the treaty bodies themselves. A final point is that there were a small number of contradictions, about 1%, so it's limited, but they existed. So cases in which different bodies gave opposite recommendations. Either they acknowledge a problem and another body said that the state was doing well on that, or they give different non-complementary solutions to the same problem. And this is perceived as very problematic because, of course, it shows that there is disagreement within the bodies of the human rights system. States do not know what to do, and often, of course, this gives leeway to states to do what they prefer to do in that situation. And this is particularly problematic when it happens among treaty bodies. So based on this and on these findings, I have to conclude just a few recommendations on how the system could be strengthened. I will not focus on the individual bodies, as many recommendations have been given on that, but I will focus really on this complementary aspect between the bodies. I have 3 shorter-term recommendations, perhaps more feasible. I have 2 medium-term recommendations, which are a bit more challenging maybe to implement, and a long-term one, which is more ambitious. The first recommendation, which should be quite realistic to implement, is to provide clearer guidelines on how to formulate recommendations, especially in the UPR, can also be relevant to treaty bodies, maybe to a more limited extent. Recommendations in the UPR tend to be achievable and time-bound often, so more realistic and taking into account the time. Whereas those of the treaty bodies tend to be specific and measurable, but less realistic, as perceived by the receiving states. So I think that unifying the way in which recommendations are given and following a specific guideline might help to make them also more useful for states and more comparable. A second recommendation that I think might be helpful would be to create a shared database of recommendations that are delivered to each state. This is what I did in my very small-scale research for 14 countries. But if actually there was such database and it was easily accessible, where experts or states delivering recommendations can easily access what is being recommended to the state before, that might also help to ensure complementarity. So now everything is accessible. You can all look at these recommendations that have been given, but they're not easy to find in the same place. You need to look for that into multiple documents. So something more transparent and easy to access might also help to streamline recommendations, avoid too many repetitions, certainly avoid contradictions. Another aspect, and this has already been recommended by others, including former treaty body members, is to avoid the reporting on the same issues to different treaty bodies. Meaning that if a state is being reviewed by the Committee Against Torture, and 6 months later by the Human Rights Committee, maybe the Human Rights Committee could focus on issues that are not related to torture, unless they see there was a gap in the recommendations delivered by the Committee Against Torture. As I said, this has already been expressed multiple times, not been taken up, so perhaps it's not viable for other reasons, but it might be a way to streamline the system. Moving to the medium-term recommendations, yes, I'm almost finished. It might help to also set up a system for follow-up monitoring that is a bit more systematic, and perhaps also note it in that database so that everything can be seen in one place. And the UN Secretariat can also play a more substantial role to help in ensure coordination. I'm happy to elaborate further later if there are questions, so we can stay on time. The final recommendation, which is the final and most ambitious one, would be to consider in the future to explore new governance models, perhaps a hybrid system that combines expert and peer input, such as we have in the African Union Advisory Board Against Corruption, or, as has been also discussed in previous panels today and yesterday, maybe a more multi-stakeholder model involving different types of actors that are relevant to this. Thank you.
Thank you very much. Thank you. This is the applause to all presenters. Most of them were virtual, but hybrid. But I would like to thank all presenters for the presentations that were very, very diversified. I now open the floor for questions to either of the 5 presentations. So what about the first question? Please.
Yes, I have a question to Valentina Carraro. It's just for better understanding. When you talk about treaty bodies, the European Court of Human Rights would be the treaty body for the European Convention on Human Rights, right? Is that correct?
No. So in this case, it's sorry.
I think just let's ask the question first.
No, I don't understand what you mean when you say treaty bodies. That's the problem. I'm trying to find out. Thank you.
Okay. Okay, next question. Yes. Okay.
Gregory Weeks. My question actually is, you give the recommendations, which I really liked. I think you're one of the few people who actually made recommendations of what could be done at the UN. But how would that take place if they actually accepted the recommendations? How would that work?
Thank you very much. Another question?
Yeah, thanks a lot. Pablo, you can't see me
I'm
now.
not hearing the questions.
Marcus Kornprobe. So we communicated by email. I'm very happy to see you there on the big screen. Pablo, a question for you. So when you think of prevention, and it seems to me you have more the long time perspective in mind. So anti-grievance mechanism would basically probably map onto root causes to be addressed. I think that's very important. But is there also the short-term perspective? So I sometimes think about, talking about mass human rights violations, genocide, for instance, usually the language changes before that. So there's oftentimes dehumanizing language happening then. And would it be possible to have a prevention, some kind of an alert system in place to address situations like that as well?
Thank you. So we have 3 questions, maybe the last one from you, because the first one was very short. So.
Thank you, Valentina. My question is, your comparative study concentrated on 14 states, okay? 14 countries. Can you specify the countries, please? Thank you.
Thank you. So, first, Mr. Ferraro.
Yes.
And Mr. Van de Greiff later.
Okay. So first of all, well, thank you actually for the question about the treaty bodies. So it gives me the chance to elaborate a bit more on their function and what they are. So these are committees of independent experts that were created to monitor the implementation of a specific treaty. They're not a court, they are considered semi-judicial bodies, so they provide authoritative interpretations of the treaty. So we are talking about the 10 major UN human rights treaties, but these recommendations cannot be enforced. So it's not a court that can, so they are considered to be semi-binding in a way. If I understand your question correctly, you asked me how the system would look like if my recommendations were accepted. Is that your question?
My question was how they would actually implement these when they say it's non-binding.
In that sense, so the recommendations by these bodies. Yeah, that's a bit the problem of the system. So that's a bit the weakness, as I mentioned, because the treaty body recommendations are not legally binding, although the obligations in the treaty are legally binding. So this is a bit the disconnect. So states should comply with those because they are binding, but the recommendations, no. That is not something that can be solved without completely restructuring the nature of the treaty bodies and making them courts. But what I've seen is that because the UPR has this political power, then if it picks up the recommendations by the treaty bodies, in those cases it helps because states feel a bit more pressure. I had, for example, an interview saying, if it's an expert giving me a recommendation, I can decide what to do. But if it's Germany giving me their recommendation, then I really want to implement it because I want to keep a good relation. So that is the difference. But it's true, in the end, we cannot really do much. Maybe regarding the 14 countries, I have a list in my paper. I'm happy to get back to you. I remember a few, I don't remember all the specific countries, but it included, for example, Russia, Canada, the Netherlands, Ghana, and so forth. So it was everywhere, let's say, all 5 UN regional groups were included.
Yes, Marcus, you are completely right. Part of the objective here is to think about a framework that does what the system has been saying it would do for ages, which is to think about prevention not just in terms of preventing crises, but in an upstream way. So several early warning systems have been created. The connection between early warning and rapid response continues to be a problem. I am very supportive, of course, of crisis prevention and of improving the rapid response. But I think that it is dangerous and pernicious to think about prevention solely in terms of crisis prevention. Measures that are taken in times of emergency leave out lots of things that do very important preventive work at the everyday level, and also focus the attention on the role of the international community, therefore sparking lots of reservations about the prevention agenda. So if you had a framework that focused on earlier steps of prevention, where most of the lessons have been learned, because this is where most of the prevention work takes place, you would be focusing more on nationally led initiatives, and therefore the topic of prevention would be less contentious for member states that have reservations about national sovereignty. So in a nutshell, that's the response. Thanks for the question.
Thank you for the answer. I have two questions to two presenters. Maybe since you are Mr. de Greiff online, we all know that an ounce of prevention is a pound of cure, and this is almost like, you know, in the Quran, in the Bible, and of course in the United Nations report of the Secretary General to the Security Council from 2004. That's taken for granted literally, but not factually. When we have started in our office, UNODC, to the work on crime prevention, we found out that really, yes, conflict prevention is something that is important for the United Nations, but not any other form of conventional prevention. Now, since you are a member of International Commission of Inquiry on Ukraine, and you said that the cultural factors in prevention are so important. One of the problems in Ukraine is endemic corruption. And corruption can drain really any utility from an assistance program, because people will start not believing that anything works. Simply, it lowers the trust in authorities, in officials, and so on, and so on, and so on. And now we are really in the midst of war in Ukraine. Is there any forward-looking thinking, the way that you exactly and very comprehensively tried to design to address this really endemic problem of corruption when the war unfortunately continues?
Yeah, so obviously there are some issues that are more difficult to deal with while conflict is ongoing. And this is another reason why I think that upstreaming prevention is important. But of course, you are completely correct in thinking that corruption is the sort of a phenomenon that undermines trust immensely. I don't think that there is a single institutional fix for corruption, either in peacetime or in wartime. But nevertheless, I think that we have found out that there is a combination of both institutional design features for anti-corruption bodies, accompanied by a greater role for civil society, the so-called transparency, participation, framework, I think is very, very important. And that something that has never been examined is the relationship between the effectiveness of different so-called guarantor or oversight institutions, in which I include, for example, epistemic bureaus, inspector generals, anti-corruption bodies, independent human rights institutions, electoral commissions. There are performance evaluations for these institutions in isolated from one another, but that ignores possible network effects, which suggest that, for example, phenomena like corruption is the type that seeps out of particular areas of competence and affect various institutions at the extreme, capturing the state, and that therefore an antidote for this doesn't depend on the creation of a single institution, like, for example, an anti-corruption institution, but rather a family of oversight institutions that can work together and provide some protection for those measures that are supposed to be conducive to transparency, good governance, and the respect for human rights. So it's more the network of institutions and the relationship between those institutions and the civil and cultural spheres that I think have been underattended massively. And that's another reason to think about a framework approach rather than individual isolated initiatives that have been shown to be of limited use.
Thank you for your statement, very incisive and very thought-provoking. And on the strength of this statement, I would like to ask you two questions. My first question is, in your talk, you have brought up an extremely complex legal issue and expressed concern that the question of, quote, Arab territories occupied, unquote, by Israel is too often on the UN agenda in comparison with the question of territories occupied by other United Nations member states. In your view, this is once more documented by the General Assembly Resolution 77/400, requesting an advisory opinion of the International Court of Justice on the status of those territories. You claim that the adoption of this new General Assembly resolution shows a double standard that could have been avoided by the General Assembly if by the same mandate other such cases would have been brought up and re-examined in the same ICJ advisory opinion. Your argument is rhetorically and academically very interesting, but isn't it really up to those countries concerned with such other contested, occupied, or annexed territories to negotiate the GA draft resolution? So indeed, the International Court of Justice would have to do it. In other words, what do you think about the progressive development of international public law by building up a coalition of like-minded states concerned with the same question as Israel is, and initiate the work on a draft resolution which matches the opposite legal position? Perhaps at the end of the day, quote unquote, that is in the next years, the entire UN membership, now so divided and entrenched since 1948, will attain a more constructive outcome than just a stalemate nowadays.
Well, I certainly would welcome and applaud the creation of such a coalition, especially if it could be effective. The problem really is that there is a political reason why Israel is submitted to other standards within the UN than the remaining member states, and that is an automatic majority voting against Israel, not necessarily because it is concerned with Israel, but essentially to remain in the good graces of the powers behind the coalition, which are the Arab League, the non-aligned movement, many Muslim countries. There simply is not a counter force within the UN at this point strong enough to break this voting machine, which used to be even stronger when the Soviet bloc was behind it, but which is still very much in place. And countries that see the absurdity of the double standard are reluctant to attack this voting machine out of fear that if this line of conflict is opened, there is much less chance of getting the cooperation of the countries of the voting machine on other resolutions that need to be passed. Therefore, Israel is considered an acceptable price to pay for the chance of getting Russia criticized, for example, as it should be for its war in Ukraine, or hoping, say, that one day it will be possible to criticize China. But if Israel is expendable, this really is a blow to the founding values of the UN, which was supposed to be a community of nations in which nations are treated alike and with the same spirit of rule of law.
Thank you very much for your explanation and answer. I'll continue with this argument of yours of double standards, and I have another question. You served as an advisor to Tadeusz Mazowiecki, earlier Polish prime minister, who later, that is between 1991 and 1995, was the UN Special Rapporteur on the situation of human rights in the territory of the former Yugoslavia. His reports on war crimes and other rights violations became one of the main triggers for creating the International Criminal Tribunal for the former Yugoslavia in '93, and then subsequent
I lost you. International Criminal, and then I lost you.
For the former Yugoslavia, and the subsequent international courts. But in 1995, after the Srebrenica genocide, he resigned from his position, protesting against, and I quote, the lack of consistency and courage displayed by the international community and its leaders, unquote. And then he also said, and I quote again, I am not convinced that the turning point hoped for will happen and cannot continue to participate in the pretense of the protection of human rights. And on several occasions, I heard you speaking very highly about his decision to resign, as if he was saying that there cannot be double standards because they are not fair to anyone. On the other hand, your question, the integrity of the UN Special Rapporteur to investigate Israeli practices on the situation of human rights in the Palestinian territory occupied since 1967. So given your own 1990s involvement in investigating the human rights violation, I have this question, and it runs. It's a bit long, but I hope this will be clear. Without prejudice to other world views or to any particular Western or Eastern legal culture, so without the pretense that one is right and another is wrong, because we have different, first, institutional rule of law practices as far as independence of authorities and investigations of truth are concerned, and because we have different individual virtue standards in a personal moral conduct, like the one to which you referred of the former Polish prime minister. So do you think, is there really any objective UN, institutional and individual, overall investigation and assessment procedure that would meet your eye?
This is a horribly difficult question, of course. I don't think that in issues of human conduct, we have an absolute standard like we have the standard of the meter conserved in Sèvres near Paris, which is totally objective, cannot be interpreted because it is an inanimate object. Humans are animate subjects. Therefore, we are always open to interpretation and criticism. And I'll be extremely reluctant to propose one particular institution or one particular procedure as the ideal to which all should aspire. I rather think that a common sense approach would be to start from the bottom, not from the top. If somebody is biased, they should not investigate the subject on which they're biased. If somebody believes, for instance, that Islam is a religion of terrorism, and sadly, there are people who believe that and say that in public, such persons should not be allowed to become objective investigators of anything remotely connected with Islam or its faith. If somebody believes that gays are an abomination, he should not be investigating anything related with LGBT people, and in my opinion, should not be investigating anything at all. Once obvious bias is eliminated, then we can approach the more subtle biases. Mazowiecki, whom you mentioned, was accused first by the Serb side, but then also on the Bosnian government side, that being a Catholic, he cannot be objective by definition, and that he will always favor the Catholics over the Orthodox or the Muslims. Those criticisms disappeared after a time because there was nothing they could feed on. Mazowiecki was not influenced by his faith in his investigatory decisions. He actually is a good example of how you can use what is an element of your identity, in this case, the Catholic faith, as a driving force towards justice and impartiality instead of a force for bias. And I still travel to Bosnia, and I remember that after Mazowiecki's resignation, Bosnian public opinion was divided. Some people were very impressed with this extraordinary act, the first resignation of a high UN functionary in the entire organization's history to protest against the UN itself. And this never happened before. But others said, we lost our only voice. Mazowiecki was our voice. Now nobody will hear us. After the years, what remains is what somebody told me once in Mostar, learning that I had worked with Mazowiecki. He said, Mazowiecki, jeden normalny człowiek, the only normal person. And maybe to conclude this long answer, one of the things that we are obliged to deliver is the feeling that we also believe that injustice is not right. There's so much injustice in the world. Its victims get used to it. And one of the things the international community can do through its common organization, which is the UN, is to tell them, no, it is not fair. You should not get used to it. We might not be able to help, but we will not help those who believe that nothing can be done. among the victims of injustice are also the Palestinians who are living under Israel's occupation. But discrimination of Israel does not help Palestinians. It helps to legalize double standards that will affect them too. The weak always have an interest in impartial justice because they always suffer when double standards are legitimized.
Thank you very much. I wanted to ask a question to Mr. Bodomo, but our time is out. It's 14:30. But I hope, since he only is for a few months away from Vienna, I can still ask him the questions over tea or coffee when he comes back to Vienna. I would like to thank you for your very attentive presence and reaction to various statements that we have heard, whether in virtual world or in the real world by Professor Carraro. We have to continue with another panel very soon. So after a very short break, I give the floor to Ambassador Marshik to continue with the next panel. Thank you very much.
Thank you very much.